Lesson 1. Selected Vocabulary. Tort. A civil wrong. This forms part of civil law, but is often mistakenly considered to belong to criminal law. In fact, in some countries, acts or omissions which constitute torts in the United Kingdom and the United States of America are classified as offences. There are 4 main types of tort: negligence, nuisance, trespass, and defamation. Negligence. This is the most common type of tort. It arises when someone who owes you a duty of care breaches this duty, and that breach causes you to suffer harm, damage, or loss. They have tortious liability. Someone guilty of negligence is negligent. Nuisance. If someone prevents someone else from using and/or enjoying their rights to something, such as a right to enjoy land. Trespass. Unlawful invasion of the person, property, or rights of another. Someone who commits this tort is called a trespasser. Defamation. This is a public statement about someone which is untrue and which lowers that person in the opinion of others. If it is made by speech, defamation is called slander. The adjective of this is slanderous. For example, saying something in a shopping centre or with your neighbours. Defamation is known as libel when it is in a permanent form, and the adjective of this is libelous. Damages. Damages are a sum of money awarded by a court to the injured party. So, if somebody has wronged you, for example, harmed, injured you in an accident, or breached a contract with you, you can ask a court for damages. You can claim damages. If the court agrees with you, it awards you damages. Damages are the most common type of remedy in common law. A synonym for damages is the word compensation, because the court, by using this remedy, is compensating the injured party. It is compensating them for their loss or pain and suffering. Lawyers say to seek damages or to claim damages. So we can also say to claim compensation or to seek compensation. To award. This means to officially give something, such as a price or money, and in a legal sense, to officially give damages to the winner of a court case. If a judge or court awards damages, they make an official decision that the claimant or defendant is the winner in the case, and will receive a specific sum of money to compensate them. We say to award damages, to award compensation. The word award is also used as a noun with the same meaning. We say an award of damages, to make an award of damages, meaning a judicial decision awarding money to a party in a dispute. To find for. This means to make a decision in favour of a particular party. If a court finds for the defendant, for instance, it gives the defendant what they have been asking for. We can say the jury found for the defendant. To hear a case. This means to officially consider a case during formal proceedings. Judges or other authorities hear cases and then make an official decision, make a judgment. They consider them, they analyse all the aspects of a legal case, they look at all the evidence, all the statements and motions, and then make a judgment. We can say, the judge refused to hear a case, or after hearing the case, the judge found for the defendant. A hearing. This word means an official meeting aimed at collecting all the facts about an issue or an event. We can say the judge set a hearing for the 20th of June 2016, or a disciplinary hearing will be held next month. It will examine charges against government officials. So, to hold a hearing or to participate in a hearing, to be summoned to a court hearing, and so on. To hold. If a court holds that something happened or will happen, or holds that something is true, it means that the court decided or determined something. It's a formal word meaning to decide something, as in, the court held that there was not enough evidence, or the judge held that the defendant was guilty. The legal synonym is to rule. The court ruled that someone had a right to do something, or was liable for something. So, for instance, we can say, the court of first instance held that the documents had been obtained illegally. The court of first instance ruled that the documents had been obtained illegally. We use the noun holding in the same meaning. A holding means a decision in a legal context. Synonyms are a judgment or a ruling. A remedy. This is protection that the law has for you if someone has wronged you, has done you a wrong. It's also referred to as relief. Notice that the word a remedy is countable, whereas relief is not countable in this context. A remedy is help that the law has for you. So we can say, the judge can grant you a remedy, or the judge can grant you relief. We seek legal relief, or seek a legal remedy. The most common type of remedy in law are damages. The other types of remedy, albeit rarely granted, are specific performance, injunctions, or restitution. But a right to return a defective product to a shop, or to have it replaced, or to receive a public apology when someone has damaged your reputation, are also types of remedies. The word is also used as a verb. To remedy means to enforce a right, to cure a wrong, or to compensate an injury. If you demand a remedy, you ask the court to prevent, correct, or compensate a violation of a right. A lawsuit. This means a claim. If you file a lawsuit, you begin legal proceedings. A synonym for this is to file a claim or to bring an action against someone. All these phrases are used to describe what a claimant, which is also known as a plaintiff in America, does when initiating court proceedings. If you file a lawsuit in a court of law, you ask the court to officially consider your claim, to hear the case. You bring a lawsuit against the party called the defendant. To informally say that we will bring a lawsuit against somebody, we can say we will sue them. We will sue them for something. For example, we will sue them for damages. A claimant. This is the party who initiates the litigation, the party who files a lawsuit. They start the claim. In America, a claimant is also known as a plaintiff. So in America, we have plaintiffs and defendants. The opposite party is called the defendant. A defendant. The party to a dispute who needs to defend themselves. They are the party against whom the lawsuit has been filed. Litigation. This uncountable noun means the legal process happening in a court of law. It starts with a lawsuit and ends with a judgment, the judge's decision, and its enforcement. Litigation involves all the activities that occur during a court dispute. For instance, it involves an exchange of documents, filing documents, calling witnesses or presenting other evidence, court appearances, court and witness experts, filing appeals, and so on. Usually, it means a lot of hearings and a great deal of paperwork. The term litigation is sometimes used to distinguish lawsuits from ADR, that is, alternative dispute resolution. ADR includes negotiation, arbitration, and mediation. A court of first instance, also known as a court of first hearing. This is the court where a claim is first initiated, where the proceedings are begun. From there, if certain conditions are fulfilled, a case may be appealed to a court of second instance or a court of second hearing, which is also referred to as a court of appeal. A judgment, otherwise known as a ruling. Judges make judgments or pass judgments. In other words, they make official decisions. A judgment or a ruling is a judicial decision which settles or decides a court dispute. Liability. This is a term which, in its legal sense, means responsibility. To be liable for something is to be legally, officially responsible for something. We say to have or to bear liability for something.